everyone. My name is Cecilia Meme. Welcome to today's program on justice, a lawyer's hangout where lawyers dissect legal topics with intent to create enlightenment, educate, and create awareness for the public. Joining me on today's program is Chidi and Juliet, leading lawyers in the legal profession.
Hello, viewers. You're welcome to our program.
Thank you for having me.
Yeah, today we'll be discussing tenancy, termination of tenancy, the issue of self-help, and the very popular fee, caution fee. In our society today, one very prevailing issue between landlords and tenants has to do with termination of tenancy. So today we'll be having a legal perspective about tenancy. How can a landlord, Barrister Chidi, how can a landlord legally terminate a tenancy in Nigeria? Also, what are the legal procedures involved in doing this?
Well, in the hierarchy of man and needs of man, housing and accommodation ranks very high. So the issue of tenancy has led to a lot of dispute and litigation. However, any landlord that wishes to terminate the relationship with a tenant, must follow the process of law by issuing the requisite notices. First of all, you have to issue 7 days notice, warning the tenant that you wish to terminate the relationship you have with him. If he refuses to quit the premises, then you issue 7 days owner's intention to recover possession. And if he fails to vacate the premises, then you go to court to file summons so that the court will issue summons or warrant to evict the tenant, because it is the position of the law that no landlord has the right to unilaterally or use force of arm to remove a tenant. If you do so, you are incurring the wrath of the law, as was advocated by the Supreme Court in case of Ojukwu and Governor of Lagos State, that any landlord that uses viat armies by arm or force to remove a tenant is incurring the wrath of the law. So you must follow due process by issuing the requisite statutory notices before quitting a tenant from a premises.
Okay, for the sake of emphasis, the procedure involved in evicting a tenant has to do with, you first of all have to issue a notice to quit. First of all, so now that notice to quit, is there any specific duration that governs it, or the landlord can just decide to issue any number of days to the tenant and that's fine?
Well, first of all, you have to understand that tenancy is contract. Tenancy relationship is contract. Like every other contract, the landlord and the tenant, they can decide on the mode of termination or mode of notices they prefer. However, generally, the law presumes, most laws, have already codified by statutory means the length of notice to be given if you want to quit a tenant. That's why some tenancy agreement will have what they call a year certain or year definite. For instance, if your tenancy is for 1 year certain, the law presumes that after the end of the 1 year, your tenancy will terminate by a fraction of time. In such a case, there are contradictory positions. Some say you can give 7 days owner's intention direct without giving issue quit notice because the tenancy has already elapsed by a fraction of time. In that case, you only issue 7 days notice to quit. However, most laws, recovery of premises law, Rivers State, FCT, Abuja, stipulates that if in absence of any other length of notice, then if it is a yearly tenant, you have to issue 6 months notice to quit. If it's a monthly tenant, you have to issue 1 month notice to quit, and vice versa. But most often, the length of notice can be agreed and abridged by agreement of the tenant and the landlord.
Okay, Barrister Muna, this brings me to the question. We've already all agreed that the right procedure in evicting a tenant is by issuing the right notices. However, we've seen in some other scenarios where some landlords do not actually go through this procedure and they go through the way of self-help. What does the law have to say about self-help? Is a landlord who utilizes the mode of self-help to evict a tenant, is he protected by law?
Okay, the landlord can never be protected by law. In fact, the law frowns heavily at any landlord who resorts to self-help. Now, if a tenant has breached the agreement, or the tenant has will, that is has defaulted in paying rent, the appropriate thing to do is to refer to what has the agreement stipulated. Is the agreement saying, if I'm tired of you, even if your rent hasn't expired, I need to issue you a notice? That's why he was talking about jurisdictions varying laws in different jurisdictions. If you agree on 1 month's notice, for example, it's different from when the tenant is a tenant at will. He has defaulted in paying rent. If you allow your emotions to take over you, you just go and evict him. The law frowns at it. And the tenant has every right to take the landlord to court, seek help legally in courts, and the courts can give an injunction for the tenant to be granted access back to the premises.
The property.
And there are also criminal consequences, civil consequences, administrative consequences when a landlord seeks self-help.
Okay. Are there also instances where a tenant can decide to go the route of self-help?
Yeah, sometimes maybe you see if the tenant is provoked. For example, the landlord just bumps into the house, brings your things, and you start fighting. That's also self-help. I think the tenant should be able to control his emotions, seek help from a lawyer. What do I do? My landlord just pushed me out unlawfully, threw my things away. Instead of fighting. We've seen cases where you see the landlord, they fight or they have altercations and it just escalates into something you didn't bargain for. So, but most often is the landlord who always goes...
wants to use the utilize self-help.
Self-help, yeah.
Barrister Chidi, this brings me to the question. Are there any grounds for eviction? Or can the landlord just wake up one morning and say, I do not want you in my house anymore, please leave?
Well,
What are the reasons? What will a tenant do that the landlord will say, oh, please leave my house? What are the grounds for eviction?
well, like I mentioned earlier, tenancy is contract. And before the parties go into the contract, they must have agreed on covenants and terms in the tenancy agreement. For instance, covenant to pay rent, covenants to be of good conduct, covenant to pay tenement rate, covenant to live in good peace with neighbors. Therefore, if any of the parties, maybe the tenant, breaches any of the covenants as stipulated in tenancy agreement, the landlord has the right to enforce the tenancy agreement by terminating the tenancy. But however, he must resort to the agreement and covenant in the tenancy agreement. There are certain breaches you can commit. You have to use the property, say if the property is for residential purposes, you are not supposed to use it for criminal, commercial, or other purposes. You must abide by the terms and covenant you have stipulated. If you breach it, any of the parties have the right to go to court to enforce the contract.
Okay, now this brings me to the question. For the purpose of clarity, you mentioned tenancy agreement. What is the role of tenancy agreement in tenancy?
Well, tenancy agreement is very important because they said the faintest writing of a book is better than the memory, so that all the parties will be added them. The tenancy agreement, it helps the parties to be sure of what they have agreed on, so that if you are, in law, they say that the parties must be added them. There must be consensus and agreement. So once there's a tenancy agreement, you must have agreed everything there, so that everybody must abide by what is in tenancy agreement. So that's why most often it is advisable that all the tenants will have tenancy agreement, because if there is no tenancy agreement, the landlord will be speaking from the left side, the tenant will be speaking, leading to confusion and mutual, chaos. So tenancy agreement is very, very important. It's a valid document you must, obtain before going into tenancy contracts. It's very, very vital.
Okay, this brings me to there's this particular scenario where a tenant actually alleged that he made payment for rent, let's say in the month of August, and 2 months into moving into the apartment, the lawyer assigned by the landlord actually said he wants to inspect the property. Usually, I know there are some tenancy agreement that comes with a term that says the landlord has the right to come into the property and carry out inspection, however, with the consent or with proper notice being given to the tenant. So I think the notice was given to this tenant, but the tenant said it was not available for that inspection to be carried out. So he communicated that a better date should be agreed upon. The lawyer refused. This is a story now I'm giving to you. The lawyer refused. So on the said date that was communicated, the lawyer came. Sadly, the tenant was not at home. The tenant alleged that his children were at home, but he could not allow the children to grant access to the lawyer for the landlord. So that thing led to an issue where the landlord came on his own and now said, since you do not want to give me access to my premises for inspection, it means that you have to leave my house. And according to the tenant, few months down the line, he got a notice to quit. Ordinarily, the rent was supposed to end, let's say, in July, but the landlord gave him a notice in December that was meant to terminate that tenancy in June. The guy took the landlord to court. So my question now is, was this denial of inspection, is it justifiable for a landlord to issue a notice to quit to the tenant? Because when you're looking at grounds of the grounds for eviction, non-payment of rent, fine, breach of tenancy agreement, but I think are there acts that one can actually carry out that the landlord will say, oh, I do not want you anymore. In this instance, not granting, because as a tenant, I have a right to quiet possession.
Yeah.
Is that act by the landlord justifiable by law? If we are looking at it from the legal angle, is it something that is right?
Well, first of all, once you have paid for tenancy, if the landlord wants you to live in his house, he must give you exclusive possession of the premises or the building. Once you have paid and all the conditions met, you are the person who is in exclusive possession of the property. Nobody has any right to come into your premises for any reason whatsoever without your consent or permission. So once you are in exclusive possession, anybody that enters there, including the landlord, they are trespassers. However, there are lawful and statutory exceptions wherein the landlord has the right to come in to inspect after giving you a reasonable notice that he wants to come there to inspect. So if he gives you reasonable, so you must communicate a day or time that is convenient for you in which they must come to inspect your building, and they must inspect it in most decorous manner. They cannot come into your premises and invade your privacy and family life. So the landlord must conduct himself within the realms of the law and family privacy. So the landlord does not have any right to barge into your house at any time in the name of supervision. He must give you adequate notice and time that is reasonable, acceptable to you. Anything short of that is trespass and is actionable.
So for clarification purposes, in this instance, the tenant has the right to actually sue the landlord.
Yeah. I think he wasn't even given enough notice.
Yeah.
You gave someone a notice, he hasn't accepted. So there was no agreed date. There was no agreed time. So there's no how you barge into a tenant's house without an agreed date. If there was an agreed date, you can now say that the tenant breached the agreement of the date and time. Because that clause even says, give reasonable time via his agents or whatever, his representatives.
Okay. Yeah. Now, this the issue of tenancy, is there any law that governs tenancy? And if there is a law, is the law a general law, or every state has a law that is applicable to them that will also govern their agreements or arrangements within that location?
Well, tenancy is not in the exclusive legislative list, so it's in the concurrent and residual list, in which only the state government and the state legislative have power to make tenancy law. So various states have their own different tenancy law. For instance, Lagos have the Abuja is Premises Act, because of Premises Act, FCT Abuja, that is applicable to this Abuja. However, you have to understand that because of rapid urbanization and the frequent dispute between landlord and tenants, that made the legislature to make law about tenancy and landlord relationship. Although the relationship was even because they were trying to protect the tenants before, but now the landlord need more protection than the tenants. Example, in Lagos, they have made a law in which they stipulated that no tenancy matter should be in court for more than a certain month, because most tenants take advantage of the process of the law to delay vacating the premises upon being issued with a quick notice. A case in point is the case of Pillar and Desbora, where the Supreme Court was very, very angry with the tenants. And now Supreme Court made as a policy law, court said, once you have been issued with a writ or a summons telling you that you are supposed to vacate a premises, whether the quick notices are improper or proper, you have gotten notice that they want you to remove to vacate the premises. It was because of the antecedent of tenants, wicked tenants, that made the Supreme Court to become angry and handed over such judgment. So there are different laws governing different tenancy, and all of them are almost the same, but they are not the same.
Okay, we'll figuring out
is not angry, but at least also looking to protecting the interest of landlord.
Yeah,
so that people don't stretch matters in court.
That's correct. We'll be going on a short break, and when we are right back, we'll be discussing the issue of caution fee. Is it a refundable or non-refundable fee?
Hello, have you or anyone you know suffered violation or oppression, regardless of cultures, identities, or backgrounds? Leadership Hub Justice and Economic Advancement is here for you. An organization created with an amplified voice to fight for you and with you. At LJE Nigeria, you will not only be heard, but also provided with legal support. Together, we can create a country where every individual can live without fear of violation or oppression. I am Aisha Shetima, an LJE member. You too can become a member today or report any violation by visiting our website, ljenigeria.org. You can also follow us on all social media platforms for more information and updates. Remember, together, we are stronger.
Welcome back from our short break. Before we went on that break, we were discussing the issue of termination of tenancy. Now we are moving on to the issue of caution fee, the very popular caution fee. We want to know why caution fee. What's the legal position with regards to caution fee? Because now, if you're looking for an apartment, there's this issue of fees that are meant to be paid. Aside the rent, there's agreement, there is agency, and then there is caution fee. What's the position of the law with regards to caution fee?
Like I mentioned earlier, tenancy is contract. Like every other contract, it is the duty and business of the parties to select items they want to agree upon. However, the background for tenancy, for caution fee is because most tenants, once they live inside people's premises, they will destroy the property and deface and devalue the property. So much so that when the landlord now gains possession of his property, the property will be in a state of disrepair. So to reduce such tendencies, most lawyers and property facility managers have devised a means to mitigate, such acts by saying you must pay your caution fee to enable the landlord repair the house when you have vacated the premises. Although it is believed in law that the house must suffer some wear and tear, depreciation. However, there are instances where the louvers are broken, the ceiling are broken, the water closet are broken. So caution fee is just caution to make you to be cautious when you are living on the premises. However, if for any event you destroy the fittings and fixtures of the landlord, the caution fee will be applied towards repair and the restoration of what you have broken. I think it's a good.
Okay, can we actually not say caution fee is legal?
Yes, caution fee is legal, and the statutes, the laws provide for caution fee. In fact, it's called security deposit because it protects the landlord, mitigates financial loss. There was a scenario where a tenant left the house, and by the time the landlord's agent got back into the house to see the little things, bearing in mind that they just had little things to fix for the next tenant to come in, and they discovered that this tenant was cooking with firewood and charcoal in the kitchen, a kitchen that was tiled. So you can imagine the financial loss on the part of the landlord, because if he goes back to the market and he can't find the particular design of those tiles in the kitchen, he may have to take out the entire tiles to replace.
It's legal.
Yeah, it's legal.
Okay, now this brings me to the question, is it meant to be a mandatory fee or a discretionary fee? Because there are some houses that you want to pay for rent. They will tell you it is compulsory. For some, they will tell you, no, don't worry, you do not. So is it meant to be mandatory, or if the landlord decides to want to take it?
Well, every landlord should. Right now, it's actually mandatory.
Okay.
Because from experience, in the past, you used to have those living in highbrow areas applying caution fee. But right now, you even find those in the suburbs as well.
Okay.
Requesting for caution fee.
Okay.
Considering the economic reality, nobody wants his property to be defaced, whether the property is situated in a suburb or situated in a highbrow area. Every landlord seeks to protect his property.
Okay, this brings me to the question, is it a refundable fee? So when they tell you pay caution fee, is it something that at the end of the tenancy you are entitled to getting a recovery? under what circumstances would you get that recovery?
Well, caution fee is like a security deposit or a bond, performance bond, in which you have to deposit to assure that you are going to live on the premises and maintain the property the way you found it when you enter. It is meant to be a refundable deposit. But however, from my experience, I have discovered that it is impossible to return the money the same amount that was deposited, because there must be wear and tear. There must be breakage. There must be some repair to be done on the property. However, in principle, when there are excesses of left after repair of what you have damaged, it's supposed to be refunded. It's a refundable deposit. In addition, lawyers have devised further means of insisting that a tenant must bring a guarantor for faithful payment of the rent and faithful payment of living in peace and then maintaining the property. In which case, if the tenant destroys or damages anything in the property, the landlord, the guarantor will be called upon without argument to come first demand, without caveat, to come and restitute and restore the premises the way it is. So many drafters now are including guarantee, contract of guarantee, so that you bring guarantees to assure you must live according to the term, pay your rent, maintain the property, and restore it for living.
Okay, there's this scenario that comes to mind where at the end of a tenancy, it was found that after they carried out inspection, they saw that there were no damages per se, but the landlord in that instance refused refunding that caution fee. His reason is that the house needs to be repainted. Is that enough reason?
That's not fair.
Because if you're looking at it, I did not damage. Ordinarily, there should be wear and tear, but also considering the occupier of that house. A house where you have children and a house that an adult is occupying might not have the same wear and tear in the long run. So if you are telling me you just need to repaint the house, so you don't want to refund my money, is it justifiable?
Okay, that's why he said drafters. When you're drafting the tenancy agreement and bringing in these clauses, I think these things should be spelled out. The caution fee should take care of damages that are beyond reasonable wear and tear. And then where you have the huge caution fee, because of course we know caution fee varies, where you have huge caution fee, it even covers up for situations where the tenant even defaults in paying rent. So the landlord can now deduct, part of his rent from the caution fee. Now, for caution fee, I think landlords should be encouraged to take proper accounts of, those damages to be paid. You don't just tell the tenants you're going to paint the house. No. For painting is reasonable wear and tear. So landlords should be encouraged to be accountable of the things that the caution fee should take care of.
Okay, yeah, this brings me to the point where we have to say, as a landlord and as a tenant, I think you should know your rights. Landlords have rights, and tenants also have their rights. As a tenant, you have a right to quiet possession. You have the right to proper notice before eviction from that property. As a tenant, you also have a right to challenge unfair eviction in court. You have a right to maintenance. In situations where while staying in that property, there are some repairs that may come up that are meant to be fixed by the landlord. There are some repairs that may come up that are meant to be fixed by you yourself, the tenant. Also note that as a landlord, you also have a right to collect rent. As a landlord, you have a right to not renew a tenancy, such that if a landlord has need for his property, he has a right to evict you. And when a landlord is evicting you on whatever reason, so long as they are justifiable, as a tenant, you can as well cooperate. Everything does not have to go to litigation. However, where as a landlord or as a tenant, you feel that your rights have been trampled upon with regards to that tenancy, please feel free to go to court and secure justice. Okay, to our viewers, is there anything you'd like to say to them?
Yeah, I want to advise the tenants, they should be very, very careful. Commercial properties are for business. It is not for religious or a moral obligation. Bringing in sentiment into residential building or commercial property is not allowed in law. You must stick to your own terms of the agreement. Pay your rent on time. Save your money immediately you have entered property. Don't go about saying that this man built this house with 1 naira and is now charging 10 million naira. Please, it is not moral obligation. It is commercial venture, and the landlords is business and investment. They must recover their property. Thank you.
Is there anything you'd like to say to our viewers?
Okay, to the tenants, I would like to encourage tenants to always seek for legal advice before taking any action. And for landlords who are bent on employing self-help, stop it. It's not right. It could bring bad reputation to you. And of course, your commercial properties, people could even run away from it, saying things like the landlord is troublesome and stuff like that. So everybody should just keep to the terms of agreement, and we'll all be fine in our society.
I hope you enjoyed our program today. Thank you for staying with us.